Informative, educational, insightful. Let's talk justice and tackle topics like constitutional rights and reform, domestic violence, rights issues that affect you. Let's talk justice. Every Tuesday, 1 p.m. to 2 p.m. on The Bridge 99 FM. Call in, share your thoughts and questions. Be empowered. Know your rights. Let's talk justice. Courtesy of Jamaicans for Justice, JFJ. Ensuring access to justice for all.
Justice, justice for all. Justice.
A wing is a win. Enjoy a KFC Hot Wings 5-piece combo or 25-piece party bucket today. KFC, it's finger licking good. The time by KFC is
1 o'clock.
Caribbean Airlines presents Reggae Sunfest 2023, July 16 to 22, Montego Bay, Jamaica. It's the biggest and baddest reggae and dancehall festival in the world. The week kicks off with a family fun day and community fest on Sunday, July 16. Then the massive free street dance on Monday, July 17. There's the all-white party on Tuesday, July 18. Then the Blitz all-black party on Wednesday, July 19. On Thursday, July 20, it's the exciting Global Sound Clash at Pier 1 Car Park. The week culminates with 2 huge festival nights on Friday, July 21 and Saturday, July 22 at the expanded Catherine Hall Entertainment Center. It's Reggae Sunfest 2023, celebrating 30 years. Sponsored by H&L Rapid True Value Flow, Iberostar, JTV, Secrets, Red Stripe, Grace, Magnum, TVJ, and H&L Agro.
Imagine you flirt with somebody and them hear your hungry belly a roll. But instead of them a judge you, them suggest getting some delicious KFC Hot Wings together. A wing is a win. Enjoy a KFC Hot Wings 5-piece combo or 25-piece party bucket today. KFC, it's finger licking good.
It's Jamaican, it's Caribbean, to the world, on The Bridge 99 FM. You heard?
The people's champion. Our mission is love. Our vision is love. Jamaicans for justice. The people's champion. Justice, justice for all. Justice under the law. Justice, Jamaica demand. Right to life, right to liberty. Justice, justice for all. Justice under the law. Justice, the people demand. Right to life and security. Oh, what a joy. Oh, what a peace. How great this country could be. Respecting your rights. Respecting human rights.
June 6th, welcome to Let's Talk Justice. I am your host, Jade Williams. I'm hosting alone this week. My colleague, Miss Mikel Jackson, Executive Director from Jamaicans for Justice, is busy doing plenty of other duties. So I am here holding down the fort this week. So this week's episode, we're talking about land and violence and what we need to know to prevent and settle disputes. And we'll be joined by attorney at law and friend of Jamaicans for Justice, Sharika Mills, to discuss some of the issues surrounding this topic. But before we do so, we will have our human rights recap. So I firstly want to mention, something that Jamaicans for Justice has already made comment about: the recent killing of a member of the JCF by his, allegedly by his spouse. She has not been convicted, so let me be careful. However, some of the issues coming out of the incident appear to be related to mental health, and it goes back to our conversations around addressing gender-based violence and specifically addressing that mental health component when talking about solutions to this issue. So I do hope that as we continue to look at legislative reforms throughout the rest of the year, that the Domestic Violence Act and those changes that we were promised will be actioned by the end of this legislative year. We would also like to bring some attention to comments made by Minister of Justice Delroy Chuck in regards to the recent sentencing of Davian Bryan. And it's a little concerning from my end, as I can see how these comments could be looked at as undermining judicial discretion. It is not as though the judges gave a sentence that was outside of their discretion to give, and having done so, considering every single factor of the case. I think we have to be careful when we make public comments about cases where the public and maybe even the commenter themselves is not familiar with every single element of the case on which sentencing was brought, that we don't undermine judicial discretion when we make these comments. But that's it for now in terms of our Human Rights Minute. I will allow Mikel to join us next week to discuss our comments on the Integrity Commission being made a constitutional body. So we go straight into our right of the day. And this week, our right of the day comes from Section 15 of the Constitution, and it relates to the protection of property. And it states, no property of any description shall be compulsory taken possession of, and no interest in or right over property of any description shall be compulsory acquired, except under the provision of a law that prescribes the manner in which compensation is to be given, and secures the rights of interest of any person claiming interest in the property and the right of access, as well as to establish such interest or such right and to determine the appropriate compensation. So essentially, this section is stating that where it is that your property needs to be compulsory taken, then there must be adequate steps to ensure that your interest in the property is preserved, or that you are adequately compensated for that interest. And we go straight into our trivia question for the week, which is, what is it called when a person gains a legal title to another person's property after solely occupying for 12 years? So what is it called when a person gains legal title to another person's property after they have been solely occupying it for 12 years? So you can respond to that by sending us a WhatsApp at 2397583, or you can send us an Instagram message, and the graphic itself will be posted on Instagram during our first break, so you can participate then. So as I said, this week we're talking about land and violence, and this comes at a landscape, behind a landscape where we've seen an increase in family disputes and family violence, many of those stemming from land-related issues. So land and inheritance have been identified as some of the major drivers of conflict in family disputes. In fact, in May of this year, Justice Minister Delroy Chuck was quoted as saying that there has been an increase in violent conflicts among family members that over what is commonly referred to as deadlift, which, as we in Jamaicans know, it is that property, that estate that is left when someone in the family has died. In many families, individual members prematurely take control of the estate after the death of a loved one, and this, Minister Chuck has said, frustrates the efforts of the Administrator General to intervene in these situations. At Jamaicans for Justice, we have also seen an uptick in reports related to land dispute, related to understanding wills or competing wills, related to inheritance, estate administration, and many of those reports would be accompanied by the issue of violence. And as we know, these disputes can stem from a mere squabble, argument with family members, to fatalities. And in fact, in January of this year, we saw where Michael Brown, a resident of the UK that was visiting in Manchester to bury his mother, was murdered by a family member over the estate his mother would have left behind. So these incidents are clearly arising more frequently, and it begs the question, what can we do when these issues arise? How can we seek assistance? But also, what can we do to prevent these issues from arising in the first place? So to have this discussion, we are joined by Sharika Mills, attorney at law, and we were hoping to be joined by someone from the Restorative Justice Unit, but unfortunately, they were unable to join us this week. So we'll hopefully have that discussion again in the future. Ms. Mills, are you with us?
Yes, I'm here. Thank you so much for having me.
Okay, thank you for joining us. I think the first thing that I would ask, I've heard the comments that a lot of these issues over estate in particular could be avoided if the person has a will. Is that an accurate statement, Talvin?
Sure. A lot of them could be avoided if the person has a will. But I want to broaden the discussion a little bit to highlight that a will is not the only way to go about ensuring that your estate, and when I say estate, I want for us to understand that this doesn't necessarily mean that you have a lot of things.
Yes,
It can mean
break it down.
anything that you have. If you have one thing, one piece of property, one bank account with some money in it. So if you own anything, then that forms part of your estate. I know when we usually hear the word estate, that people think it refers to something major or something very large, but it can be one thing that forms part of your estate, and then that's fine. But I want to highlight that estate planning is important generally. That a will is just one part of estate planning, and that you can make decisions even while you are alive that helps to protect your family even after you pass. And so, even outside of a will, estate planning is important. And then, even when you do have a will, I will say that open conversations are always important too. I know a lot of times when it comes to property, especially in Jamaica, and especially with our parents and grandparents, when we think about some of their reservations around being open about what they own and, the way that they own these things, because we know we can own property, but there are different ways to have legal interest in property. You don't have to be the sole owner of property either. And so just open conversations around those kinds of things can really help to prevent family disputes at the end of the day.
So you're bringing up a lot of important points that I'm going to press you on now. So when you talk about
Sure.
The estate planning, when I think about that, I really just think, okay, counting up the assets or what I consider to be assets and writing a will. So what else could I be, should we be considering, especially while we're alive?
Okay. One example I could give is, say in your will, you are one single person who is not married. You have one child, for example, and you have this one property, and you know that you are going to write the will leaving this property to this child, right? And there are always considerations to have. And so I will give this advice also by saying you need to visit an attorney to talk about your estate, and to figure out what is the best plan for you, because the facts, depending on your case, the facts that exist might shift what the solution might be for you. So take everything I say with also the acknowledgement that you need to go to an attorney at the end of the day to sit and talk about your specific situation, right? But just for general information, say you are a single person, you know that what you will write in your will is that you're giving this one property to this one child. How about during your lifetime thinking of ways to have you and this child hold the property now as maybe as joint tenants, in that there will be a simpler process at the end of the day to have this child be the sole owner of the property than having to go through the process to probate that will and then doing the transfer afterwards.
Okay,
And
hold
so
on.
there
So
are things you can
slow down
consider
for my listeners. So when we say joint tenants, why would that be better than any other situation? Is it, yes, explain for them why joint tenants would be better.
Sure. And when I say tenant, I don't want you to think of a tenant in terms of a lease. I want you to think of ownership, right? And so joint tenancy occurs when you have two, or it can be more people having ownership over the property, all of you having the same kind of ownership, which means one person cannot do anything with the property without the other person, and also means that the property is decided based on the rights of survivorship. So depending on who dies, in what order, the property will be left in the ownership of the last surviving person. And so we can see how that takes it outside of the process of having to resolve a will to mean that you can be the owner of this property. And it's a much simpler, cheaper process.
Okay, great. Thank you so much. We're going to take a quick break, and then when we come back, I have a few more questions for you as it relates to this estate planning thing.
The future of advertising to the diaspora and Caribbean markets resides only on the bridge. Get on now. 876-669-5000.
Yo, dancehall can't start when the money must shut the content.
Right. Introducing the Bridge 99 FM Dance Hall Chart Show.
I are the one and they are what?
All about our weekly top 10 music countdown, our Bridge Spotlight featuring artists and music producers, and our chat with the Bridge Jocks and music director.
We bring you in on the action. Just send your videos every week for your favorite artists on the chart in our Fan Affair segment. Do it WhatsApp 876-551-5782.
Jogger!
It's new, it's authentic, it's trend-setting, and only on The Bridge. The Bridge 99 FM Dance Hall Chart Show, hosted by Shell.
You know the vibes. This Friday at 1 p.m. at the wickedest thing since dancehall. You know the thing go. We're bringing the vibes to the where, to the what, to the world.
Last year, Reggae Sumfest was on fire as a host of top-flight Jamaican artists turned out for an unforgettable musical tribute to iconic dancehall producer and prolific hitmaker Dave Kelly. This year, it will be magnificent as leading Jamaican entertainers across generations will come together to honor one of the most influential figures in modern popular music, producer and sound system operator extraordinaire, Lloyd James, the man we have come to know as King Jammy. Yes, it's tribute to the king. Reggae Sumfest 2023, Catherine Hall, Montego Bay, Jamaica, July 16 to 22. You can't miss this. Sponsored by H&L Rapid True Value Flow, Iberia Star, JTV Secrets, Red Stripe, Grace, Magnum, TVJ, and H&L Agro.
King James, play sweeter, stronger, better.
You're now in tune to
The Bridge 99 FM
from Jamaica
To the world.
Right.
The people's champion. Our mission is love. Our vision is love.
Welcome back to Let's Talk Justice. We're having a conversation today about land and violence and how we can help to prevent some of the familial violence that is related to land dispute in Jamaica. I remind our listeners that this is a call-in show, so if you'd like to make a comment or ask a question of our guests while we're on air, please call in at 876-676-4996, or you can send your comment via WhatsApp at 876-239-7583. So welcome back, Miss Mills. Are you here?
I'll sigh before I answer this question because, you can prepare it yourself. Technically, it is something you can do yourself. Mm-hmm. But I do not advise that is something that you do by yourself, because this is something that will become of importance at a point when nobody can ask you additional questions about what you meant or what you intended to be there. And so it's very important to have extremely clear language. And I think this is why sometimes, even when a will does exist, there are additional issues with the family, even after that. Sometimes the instructions in the will are just not clear. Sometimes the will itself is not valid because of the way that it was signed. There are rules.
So hold on, I want to stop you there. So you're saying that there are actual, there's a form that you're supposed to follow, that if you don't follow, it's not valid.
Not necessarily a form, because I know when I say form, people will immediately think of the will form that you can buy, for example, in bookstores.
Right.
And it's not necessarily that there's a form as to the substance, but a form as to what is supposed to happen when it is being signed. The witnesses, the executors, there are rules around all of these things. And so, for example, your executor is not also supposed to be a beneficiary and a witness. And so, just those things can lead to issues at the end of the day if you don't know those particular formalities. And so I would advise that, you know best what you want to be in the will. So at the end of the day, your attorney who prepares your will is going to ask you what you want to be in the will. And so preparing it with an attorney, you don't have anything to worry about in that regard, but you do get that security of knowing that the will that you have prepared is something that can be used according to how you wanted it to be used at the end of the day when you have passed. Because remember that when this becomes of importance, you won't be there to help to fix anything. And so we will just have to use the document that you've left behind. So go to an attorney to have your wills prepared. And if you already have one prepared, have them looked over by an attorney so you can know if you need a new one or the one that you have is sufficient.
Okay. So you're saying I can have it prepared and go to someone to get an opinion on it?
Yes, if that person is willing to do that.
Okay. All right. So another question I have for you. I know that you are a mediator as well.
Yes.
And when we talk about these issues that arise where there is no will, for example, and there is contention over where things are supposed to go, outside of the administration process, do you think mediation can serve as a forum to help settle some of these issues?
Yes, mediation is a forum to help to settle some of these issues. I will say, though, that there is a specific way that these matters will go when there is no will. And so the law does prescribe who will be the person who will be in charge of administering the estate, which is the person that will be doing the distribution of the assets along with anything else similar to an executor, but in this case, there's no will. And so that administrator would be acting in that way to clear things up. And the law also prescribes how the property is to be distributed as to, who the beneficiaries will be and how much they're supposed to get.
Is that an automatic process? Is that an automatic process?
No, so you will still have to go to an attorney and go through a process of administration, right? And so you will still have to apply to the court to be granted that order to say that this person is in charge of the administration, and then they will do the distribution as to what the law says. But I will say where mediation can come in is to clear up some of the other issues that arise around the distribution of the assets. So, for example, some misconceptions that can be cleared up are, I know a lot of times people think that the person who has been granted the order to administer the estate is the person who has been granted every single piece of property and everything there is to own within that estate. And so I think even just simple explanations like that, sometimes it's not a matter of what the law says people should get that they really have an issue with, but it's the way that it's being dealt with. It's how they feel during the process. And so stuff like that like mediation, restorative justice, other forms of resolving your conflict outside of courts can be helpful to keep the family together at the same time as resolving the dispute that you guys have around the property.
Okay, so what are some of the considerations that I should have as, say, for example, a 50-year-old person, adult children, coming close to my retirement age? What are some things I should be thinking about now to start that estate planning, or should I have already started?
It's never too late to start. Don't think because you haven't already started that you're just going to throw the entire process away. But I'd say you need to sit with someone. of the transfer tax would probably be the biggest fees that you have.
I see. Well, I think I want to delve a bit more into some of those alternative options that we spoke about. So I know that we spoke about the joint tenancy and we just spoke about creating a trust, for example. Are there any other things that you could recommend to our listeners to assist them in ensuring the proper inheritance of their estate?
So, I can't think of anything at the moment, but I can give more clarity around creating a will, since I know at the end of this discussion, that will still be what is the easiest thing for people to do.
Yes.
Something you could probably do immediately. You could do it right now if you are in the state of mind to do that. And then also those will forms that I mentioned, if they're used in the correct way, they are not always bad. And take note of all the qualifiers that I used around that. So if they're used in the correct way, they're not always that bad, right?
Okay.
But they can be used. I have seen them used and the will is still valid, right? So some people have been able to do this.
Okay.
So I'd say you need 2 people, 2 executors. These executors are going to be in charge of actually distributing the assets at the end of the day. And so you want to choose 2 people that you trust, but then you also want to talk to these people before to let them know that they are going to be executors on your will, so that this is something that they can agree to, because it is also within their right to renounce this responsibility, and you don't want that to be the issue at the end of the day, that your will has no executor, and now you are going to have to apply to the court to ask them to figure, who is supposed to be the person for this, or having additional applications along with the application, even though you have a will, right?
Okay.
So I'd say you need 2 executors, so that even if one passes, there's still one that exists to carry out the responsibilities. You need 2 witnesses, and you need yourself, and you need to write this will and have everyone present. There are technicalities around it, but the best way I can tell you to do the correct thing, have everybody in the room and sign the will, and in that way you sign, the witnesses sign, and you have a will. Keep in mind that you don't have to have a property to make a will. You don't have to be giving away anything in your will. You can make instructions as to how you want your funeral to be planned or to go. You can give instructions for how you want your child to be taken care of, or who should be the guardian for your child, for example. All of those things can be put in a will. So it's not just about giving things away. Any instruction that you have that you want people to be aware of after you passed, that can be put in your will. And so that's the advice that I have if you're planning to create a will.
Okay, well, coming out of that very useful information there, I do have 2 questions.
Sure.
So the first one is, what would happen if your executors were to die, for example? Both of them die and now there's no one to execute your will, or what would happen if they're in some way incapacitated? So maybe they've become mentally ill, or they're no longer capable of carrying out that duty. Is it that everything goes to administration, or what's the process there? That's the first question.
There's actually a particular process for that. That is actually, it won't go to administration. So the things you have written in it, as in the instructions you have, the way you want your property to be distributed, that can still be respected.
Okay.
It will go to a particular process where it will be administration, but the will be annexed to this administration. So even though you will technically have an administrator, and it will go according to those particular rules as to who is to be in charge of administering the will, it is different from the general process of administration.
Okay.
But there's a process that exists. And so even though you will have the administrator, your will still be respected, but you still want your executors to exist, right? And so use 2. It's very unlikely that both of them will pass.
Okay.
But it's also possible that both of them might also just not want this responsibility.
Okay.
But that's okay. Still create your will. you will end up having possibly a different person in charge of the distribution than you envisioned, but at least your wishes can still be respected.
Okay, so another question. Does your executor have to be a certain age before you can put them in the will as an executor? Like, are there requirements around that? And also, can you have more than two? Like, suppose I want to be super due diligence and have like 4. Like, is that possible?
You could do that, but then you want to think about what happens if all of these persons remain alive, and then all 4 of them are now supposed to decide how the distribution will go, or all 4 of them will now have to agree on how to do things. And so that might create its own issues, but there's nothing barring you from doing that. They have to be adults, and so your executors can't be children. Make sure that it's someone responsible, someone you can trust, someone of sound mind. Those are the considerations I say to have. They just can't be children, and they should be of sound mind.
Can they inherit?
Do not have them serving. There are 3 people outside of you that will be on your will: your executor, your witness, your beneficiaries. Do not have one person serving all 3 of those roles, for example. Do not,
So can an executor or a witness be a beneficiary?
An executor can, but the witness can't.
Okay. So
those are some of the little peculiarities
things
I was mentioning earlier that you want somebody to be aware of when helping you to do this.
So if I sign off as a witness on my mother will, I can't get nothing out of the estate. That's what you're telling me.
Yes, that's what I'm saying. But then also think about how this rule can serve to protect people, because your witnesses are the persons that are supposed to ensure that you are in your right mind when you're signing this. They are the persons that are going to attest to all of this to the court if there are issues with those considerations. About the time of signing of the will and what happened during that time, then the witnesses will need to answer a lot of those questions. And you don't want this witness to be someone who is swayed at all by the fact that they have something to gain from this will. And so we can see why it's important, even though it might be, a peculiarity that's not loved by a lot of people.
Yes.
Hi, I'm Ronald Thwaites, and I'm the host of The Public Eye and The Open Mind on The Bridge 99 and Irie Jam in the Tri-State area. This program will tell you the truth about life backyard. Fair, open talk. No gossip, no slander. We want to listen to your concerns. Also want to help you with your problems in JA. We at The Bridge rate you and affirm our oneness as citizens of this blessed land we love. So join us now on Wednesdays on The Bridge, crossing the waters, linking Jamaicans and Jamaican lovers everywhere.
Imagine your advertising dollar reaching your Caribbean and diaspora target beyond borders in a single rotation. It happens only on The Bridge. Call now to advertise 876-669-5000.
Reggae Sumfest celebrates its 30th stage in this July. Reggae Sumfest, the greatest festival on earth, will be bringing the energy and vibes. Kicking things off Sunday with a family fun day, followed on Monday by a street dance. Tuesday, the all-white party blitz, and Wednesday, the all-black fashion statement. closing out Thursday with the Global Sound Clash, and then all roads lead to Festival Nights 1 and 2, with performances from Chronic Law, Kabaka Pyramid, Valiant, Morgan Heritage, Tommy Lee, Richie Spice, Ja Vinci, Tanya Stevens, Massacre, and many more. Reggae Sumfest, the greatest festival on earth. Get your tickets now at reggaesumfest.com. Our music, our festival.
The Bridge 99 FM, the Caribbean's cultural capital.
The people's champion. Our mission is love. Our vision is love.
Welcome back to Let's Start Justice. We've been having a very educational discussion this week talking about land, all the issues surrounding it, and how we can prevent some of those issues with proper estate planning. And I have been joined by Sharika Mills, attorney at law, and I had one other thing in my mind as we were discussing this, and we have just received the trivia winner. Which is helpful because the issue that I wanted us to talk about is the response to our trivia. So the trivia question was, what is it called when a person gains legal title to another person's property after solely occupying for 12 years? And the winner is Confident Palmer on Instagram, so we'll reach out to you. And the answer was adverse possession. So, Sharika, I wanted to ask, is there a possibility for adverse possession to come into play with some of these discussions that we've been having here as we talk about planning estates? I know a lot of persons have, for example, land that they were gifted many years ago that they haven't seen since they were a child and may have been taken over. So just explain to us quickly what adverse possession is and how that may affect our estate planning as we move forward.
Sure. I hope I can do this justice. And so adverse possession can happen if you have lived in an open way, meaning you're not hiding. Undisturbed, meaning no one has come to you to say anything about this property or made any attempts to remove you from the property, for example. So if you have been in possession of that property in an open and undisturbed way for 12 years or more, you can apply for legal ownership of that property. So that's what we're just discussing as adverse possession. And I will say, if you are someone that has been gifted property and you have not gone to see that property, then the two things I said first, that is what will help you. The person needs to be in open and undisturbed possession. And so you need to just go and disturb the possession that they have in some way. Show up at the property, make it clear that you are the owner of this property and you have not given them permission to be there. Send them a letter or some kind of correspondence. So it's that you need to go and visit the property that you own. You need to go and see what's happening there. You need to make use of it. Land is to be used. And so go and try to make use of the property, or otherwise go and try to disturb who is making use of it for you.
Is there anything you can do after this person has gained legal title to regain your original interest, or is that just lost?
Well, if you can prove in some way that it wasn't open or undisturbed, then yes.
Okay, but if I really never know, then I'm not going to get it back then.
No.
Okay. So, and then I think that leaves, I think my final thing I wanted to ask you is just about gifts. Because a lot of times I will hear somebody say, like, yeah, my mother give me a piece of land in the country. My father give me a piece of land where his farm is. But there is no associated documentation with the gift. So how can we formalize those things before it becomes a matter of dispute?
Well, I think that's where the initial points I was mentioning of having those kinds of open and frank discussions with your family members about what you own and what you intend to do with what you own becomes important, because at that point I would want to find out if someone has given something to me, if this information is part of their will, and that is the way that you can formalize it. I don't know outside of that. You need to have the person write this down in a will to say that you are the person that they want to give this property to, describe the property accurately, and make sure that they own it so that they can give it to you.
So can you will a property that you don't have a lease for, or not a lease, a title for it? Can you will a property that you don't have a title for? Okay.
So outside of a registered title, there is a way to prove that you own the property. And that's just the documents that you have. We call it a common law title. And so whatever documents you have that relate to your ownership, we would just go back about, say, 30 to 40 years in trying to, in terms of the documents, to try to trace from that time who is in proper ownership of the land, and then to make sure this is something that you could leave in a will. But just because you don't have a registered title doesn't mean it's something that you can't, that you even don't own. You do own this thing. You don't have a title for it. That doesn't mean you don't own it and that you can't pass it along. But what it does mean is that there's an additional process to figure out the ownership for the property. So if you have wills, for example, that show it's been left to you, you know, different documents that show ownership, then that's helpful. And I will say, because I know a lot of people have this misconception that a property tax document does not mean that you are in ownership of the land. It can help to prove how long you've been in possession, but that does not indicate ownership.
Okay. All right. Wow. Okay. Thank you so much for joining us, Sharika Mills. It was a great discussion, and I hope those of us who were listening who did not ask our questions will send in any additional questions that we have to our social media pages. You can also make a comment on the YouTube video that this will be streamed on. Do you have any final words to say to our listeners before we go?
I guess finally, the one thing that perplexes me, having to deal with the land issues, and when I say having to, I don't mean that as a chore, right? But it is a bit difficult when clients only approach you when things have gone so bad that it's going to take them through a long, complicated process to resolve the issue at the end of the day. And so the advice I want to give you is do something before something do you. And so, you know, go forward and try to figure things out. Try to see where you are. If you think you have someone that something that someone has given to you, make sure that they've actually given this thing to you. And for older people, I will say, be open with younger people in your family about property, about things you own. Have open conversations about what will happen after you pass.
And so if they want assistance from you now, where can they find you?
I will say you can. My email address is my name, law@gmail.com. That's SHEREIKAMILLS, law, LAW@gmail.com. You can send questions there, and I probably be open to answering depending on my availability.
All right, great. So thanks again, Sharika, friend of JFJ. We were able to exploit you for this whole session, and I appreciate the information that you were able to give us. So we are winding down to the end of the show, and I am pleased with the discussion that we were able to have this week. As I said, we did already have our trivia winner, and the answer to our trivia question was adverse possession. So yeah, I think we can close it out for this week. Thank you so much for joining us. I am Jade Williams. I'm the policy and advocacy specialist at Jamaicans for Justice. And this was Let's Start Justice. We'll be back next week at 1 p.m. same time, Tuesday. So we'll see you then.
Justice, the people's champion. Justice, justice. justice for all. Justice under the law. Justice, Jamaica demand. Right to life, right to liberty. Out of many we are one in a Jamaica. Make it a better place for the boys and girls. Created equal by the creator. For equal rights and opportunities. No to unlawful detention and police brutalization. Class, gender, race or religion. We not tolerate discrimination.
To join the fight against injustice, contact us at 755-4524 or Jamaicans4Justice.org.
The people's champion.
One love, one art, one Jamaica. On the Bridge 99 FM.
We up, yeah. Free up, yeah.
Calling all bridge builders to the Bridge 99 FM, your global partners for outside broadcasts, connecting you from Jamaica to the world.
Where will we go?
From Kingston to Portmore, downtown, Spanish Town, Canada, USA, and as far as Dubai, we keep you connected across the 7 continents of the globe.
Call us at 876-630-3153 for information about partnering with the Bridge 99 FM.
That's